Hello, everyone. Today's topic is October's coming attractions, changes to sexual harassment law in Maryland. Our speaker today is Peter Guattery, attorney at Whiteford, Taylor and Preston.
Thank you. For all of you who are interested, welcome joining this webinar. It's going to be a short webinar to bring you up to date on one of the least noticed changes to Maryland law that occurred in the last General Assembly session. While everyone was focusing on the $15 an hour minimum wage that goes into effect gradually over the course of several years, there was significant changes to sexual harassment law in Maryland that were enacted primarily by a unanimous chamber and then signed by Governor Hogan. These changes in the law are to a large extent procedural. However, they may have some significant impact in the ensuing years. So before we get into what the changes are, just a brief refresher as to what the current law provides, specifically as it relates to sexual harassment. In Maryland, the state non-discrimination law applies to employers with at least 15 employees. There are local jurisdictions which have lower limits on the number of employees in order to have coverage under the local laws, but the state Human Rights Act requires an employer to have at least 15 employees. Independent contractors are not considered employees. Prohibited practices include discharging, failing or refusing to hire, or otherwise discriminating against any individual, discriminating in terms of compensation, terms or conditions or privileges of employment, or other types of discrimination. Harassment is not listed in the current law as a prohibited practice, but it has developed as a form of discrimination through case law. It dates back to the 1970s in the form of a federal case that came out of the District of Columbia Federal Court, which defined sexual harassment as a form of sex discrimination. And that has been the practice under the Maryland state law as well, recognizing sex discrimination as a form of sexual harassment as a form of sex discrimination. The current law also has certain limitation periods that apply. Employees are required under state law to file a charge within 180 days, but in a deferral state such as Maryland, the employee may have up to 300 days to file a charge. In some local jurisdictions, that period of time for filing a charge is up to a year. And that time period for filing a charge is important because a charge needs to be timely filed in order for it to be sufficient to start an investigation by the investigative agency or to provide an employee with a right under the state law to file a private lawsuit, which they do have the right to do so. Those private lawsuits must be filed within 2 years of the alleged act of discrimination. Claims under Title VII must be filed within 90 days of the issuance of a notice of right to sue letter from EEOC. That's the federal law, and what that means is within 90 days of the receipt of a right to sue letter, whenever received, then the clock starts ticking for a federal claim. But for a claim under the state law, the requirement is not simply that you file a charge, but that any private lawsuit be filed within 2 years. There are provisions for causes of action through the state, through the Attorney General. However, that is not a focus of my presentation. That is a different process and not affected by the law. So what are the changes to this law? Well, the law adds engage in harassment of an employee to the list of prohibited discriminatory conduct. It is now specifically listed as a prohibited act. As a consequence of that, the law has to define harassment. And it has a definition of harassment to include harassment based on race, color, religion, ancestry or national origin, sex, age, marital status, sexual orientation, gender identity, or disability. Those are all factors prohibited for which you're prohibited from discriminating against somebody under Maryland law. And then this sentence tacked on at the end, quote, and retains its judicially determined meaning, except to the extent it is expressly implied or impliedly changed by this subtitle. Well, what does that mean? Well, it means that courts are going to look to the case law to determine what harassment means under this statute, that this particular provision of the law was written with those court decisions in mind. But mind you, not all court decisions are necessarily consistent, so that's going to leave some ambiguity in what this law specifically means. And it also is going to leave open a question of, well, what is expressly or impliedly changed by the subtitle? And I'll get to one possible example of that in a minute. Broadens the definition of employer for employment discrimination. For complaints alleging harassment, only one employee is needed. Note that this only applies to harassment claims. For race discrimination that's not based on harassment, or sex discrimination that's not based on harassment, there must still be 15 employees. But for any complaint which alleges harassment of any kind fitting within the definition of this statute, only one employee is needed by the employer. This greatly increases the scope of the Maryland Human Rights Act with respect to addressing claims for harassment. It eliminates the potentiality of wrongful discharge claims based on harassment, which may be a positive. However, it greatly expands the scope to employers from 1 to 14 employees. Notice also that the definition of employee has been expanded to include independent contractors. Now, note specifically that independent contractors as employees are covered as employees with respect to all aspects of the non-discrimination law and not just harassment claims. So, one employee for harassment claims, independent contractors, now employees for any type of discrimination claim. That's a significant change and could be a factor that you hadn't considered, where you said, well, I'm just having a contract with them. They're not employees. They're not covered under the law. I don't have to worry about discrimination claims. Now you may have to. The law also includes new language on liability. Now, this language appears to encompass what is currently the law. But the law is judicially determined, so that makes it somewhat difficult to nail down, a bit like Jello to the wall at times. But now that it's specifically codified, the court's going to be looking first and foremost to the meaning of the words of the statute than necessarily to legislation. In an action alleging harassment of an employee, an employer is liable for the acts or omissions toward an employee or applicant for employment committed by an individual who undertakes or recommends tangible employment actions affecting employees or an applicant for employment, directs, supervises, or evaluates the work activities of the employee, and if the employer's negligence led to the harassment or continuation of harassment. Now, note I said that this text appears to be drawn from case law as it's developed with respect to employer liability in the case of harassment, whether it's actually somebody suffered an adverse job action, i.e. a tangible employment action, to what extent the person supervised the individual and to what extent the employer knew about it and or was negligent in addressing that conduct. Keep in mind, this does not say that it's adopting any prior judicial formula. So we don't know exactly how this may develop or whether a court might interpret these as somewhat broader limitations on defenses employers may have under the law than would be available under current case law. Certainly current case law is subject to some degree of variation in how one reads it and one argues in particular cases. The statutory language may be more narrow. We don't know yet, but if anything, this is an instruction to employers to look at their policies, undertake training, specifically training, and to ensure that their policies are effective and they work to eradicate any improper conduct in the workplace. Another significant change in the law is changes to the limitations period. A complaint alleging harassment must be filed within 2 years of the date of the alleged harassment. Note, Maryland law is originally 180 days. 300 days is allowed for filing a federal claim, but now the court or the law is expanding the definition of harassment or claims of harassment for 2 years for filing a charge. 2 full years. That's a significant expansion, and really raises the stakes for employers who may have somebody who left, almost 2 years ago and then files a charge, and you have no idea why that person is filing a charge because you never got a complaint. Fortunately, at that point in time, you may have disposed of employment records. So with respect to retention policies, this certainly is ringing an alarm bell. Now, the period of time for filing a lawsuit, a private lawsuit under the statute, well, this law takes effect October 1st, so it'll be effective October 1st. Complainant may bring a civil action against the respondent alleging unlawful harassment within 3 years. So now you have a 2-year period for filing a complaint, and then a civil action, private civil action, can be brought within 3 years. So you're essentially expanding the time frame by a little bit more than a year if you take into consideration the deferral state rule of 300 days, and an additional full year for bringing that private action. And as I said, the bill is being construed prospectively. That means it won't apply to any claims that precede October 1st, 2019. So there is time to get acclimated to and prepare for this rule as it goes into effect, to understand its ramifications, and to see, well, this might be something that we need to do in order to address harassment claims, so that we're not going to find ourselves on the short end should somebody take advantage of this and file a claim many years after the fact. There are also changes for state employees under this bill, notably with respect to training provisions for Maryland state employees, and also for the scope of protections for persons in the state legislative complex. I'm not going to go into those today. I assume most of you are private employers, but just be aware that if you are within the state government, there are specific changes that affect you and your institution. Thank you, everybody, for taking the time to chime in to listen to this. If you have any questions, please feel free to contact me. I'm always happy to discuss this new law or any other issue that might come up. Thank you.
Thank you, Peter, for speaking on today's topic, upcoming attractions, changes to sexual harassment law in Maryland. If you have any questions, please contact Whiteford, Taylor, and Preston.